a secret or wanna tell. She spins a wild story, sets sail without a sail. Fake baby bumps, she's got tricks up her sleeve, but the boys see through it, they just can't believe. Oh Laura, 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 what did you do? Play and pretend just to make it through. The boys fight back, they're standing tall. Laura's big surprise is no surprise at all. She points her finger, you're the bad guy now. But truth's got legs and it's taken a bow. Her plans unravel like a thread on a spool. Life's not a game and you're breaking the rules. Lies and lawsuits, so what a show. The justice is coming, it's starting to grow. You can't win hearts with tricks or a fight. The truth shines brighter than a starry night. Oh Laura, Laura, what did you do? Play and pretend just to make it through. The boys fight back, they're standing tall. Laura's big surprise is no surprise at all. So kids, remember, don't twist what's true. Life's much better when you just be you. Laura's learning the hard way it seems. Honesty's the hero in everyone's dreams. Oh Laura, Laura, what did you do? Play and pretend just to make it through. The boys fight back, they're standing tall. Laura's big surprise is no surprise at all.
Hello, folks. Yeah, we are back with the saga that keeps on going. Laura Owens. Ugh. And this time, the good people at Victims of Laura Owens have dug up her petition, appellant's ex parte application for extension, and where she makes claims which are interesting to say the least, but also very, very revealing. Oh, there are some things in there that, but just a little bit of scrutiny. Yeah, she's lying again. Yeah. And she calls the judge in the Mike Marraccini DVRO case. Well, not outright, but basically calling that judge a liar for not doing what she tells her, what Laura tries to tell her to do. It never ends, because for Laura, this is her punishing the men she believes wrongs her by not wanting to be with her. And well, in all of this material that they dug up on the Victims of Laura Owens webpage, they also dug up what Mike Marraccini's, because they are asking for lawyers' fees in the dismissed DVRO case, which will be a hearing soon. Let's see here. scheduled hearing for July 20th to address the attorney's fees and cost, and which might be postponed because on June 29th she has been granted this extension for filing her appeal, which means that Mike will have to respond, which will cost. This is again Laura punishing Mike a decade after he rejected her, a decade after she did the pregnancy scam with him and the temporary TRO she took out on him and extended TRO. She's been punishing this guy who literally has not talked about her or spoken to her other than court hearings since, I believe, 2018. So 8 years. And she still claims she needs this. I believe he's married with kids, or kid at least. He does not want anything to do with her, and she can't have it. And it's infuriating that Laura Owens plays the court to this extent. Because courts in these cases is on the side of caution. On the side of caution. And she uses it to punish people she believes wrongs her. Because while she does this frivolously, and with the help of Ginger Ass, who I believe is still in the background for this as well, because there's no way she could have written this by herself. So she does it without cost. But Mike, he has to pay his lawyer. And it's infuriating. It's not fair. But she keeps doing it. Now, let's see here. Where do we have Mike's? There it is. I'll copy it in. There it is on YouTube. I pinned it, and here it is over at Rumble. Hello, folks over at Rumble. And hello, by the way. Hello, folks. Good to have you here. Good to have you here. LMP, Ryan Poole, Wildcats, Nicola Cox, Denise, Calamity Jane, Holy Ann Crow, Stringabell, Kerfuffle, Just Jan. Who else is it? Dave. Everybody who's here. Thanks for being here, listening to this. Continue saga. Now, hopefully, once the criminal case is on paper, that will be a hearing on that now mid-May, if I remember correctly. What was it? Was it 12th or 15th? I don't remember. But the deadline for her plea deal was end of January, and I haven't heard anything about her taking a plea deal. So it has to go to trial unless we just haven't gotten the information. But once everything there is on file, once the trial is gone through, once she's convicted, which I believe she will be, all of that will be sent to every judge, every court that she tries to pull this scam again. It won't stop her, but it might tell the court to fuck off, tell her to fuck off. All right. Let's go through it. This petitioner appellant's ex parte brief. Let me put myself up here. Court of Appeal, First Appellate District, electronically received. Now it's already been granted. Her extension to June 29th. So we have to wait a while more. I would assume that she will try to extend it again. Anything to hurt people. Anything to hurt people. I'm Mika's headphones. I finished reading through all of Omar's motion, affidavit, and exhibits, and I am raging. As everybody should be. As everybody should be. But this is the petition of extension that was granted, probably on the side of caution. Laura Owens petitioner versus Mike Marraccini, respondent. Petitioner appellant's ex parte application for extension of time to file opening brief. Petitioner appellant Laura Owens applies ex parte pursuant to California Rules of Court, Rule 860, for a 60-day extension of time to file her opening brief, currently due April 28th, 2026, to and including June 27th, 2026. How'd she do? No, I just started. Introduction. On November 5th, 2025, petitioner's request to renew a domestic violence restraining order was dismissed for non-appearance on a record that does not accurately reflect what occurred that morning. Since that dismissal, petitioner has actively sought appellate representation, which means, yeah, nobody wants to take her case. In the weeks immediately preceding this filing, two sources of legal counsel who had each conducted substantive reviews of this matter declined to represent her. Her? You are filing this, Laura Owens. Shouldn't it be declined to represent me? Ginger ass, you need to stop helping Laura Owens. You are an accomplice in her delusions. Not because the appeal lacks merit, but because the facts underlying it are not in the official record. Really. Both stated they would reconsider once that deficiency is corrected. That would be two attorneys telling her, sure, come back if you get this corrected, which you claim, and then I will take a new look at it. So not would reconsider, nah. That is the two attorneys that saw her who said, oh, you're saying that the transcript is incomplete? Well, you have to rectify that, and I will take a new look at it. The 60 days petitioner request are what is needed to correct that record, secure the representation these reviewers have confirmed this appeal warrants. Here's the thing. If they reviewed it, they have given her legal advice. I don't think that is what happened. They took a look at it. They said, fuck off in the nicest possible way, and have no interest in representing her. and prepare a brief that accurately presents what this court is being asked to decide. So her extension is she believes she can correct the record in the lower court, then get one of these attorneys to file this opening brief. I would be immensely surprised if that happened. And she will ask for a new extension, prolonging the abuse she does to Mike. The record deficiency is traceable to a specific and documented procedural problem. On December 3rd, 2025, petitioner filed a motion to correct and augment the record in the San Francisco Superior Court. That motion was never contested and was never ruled upon. The case was over. And never contested? Don't care. Never ruled upon? I don't know. I haven't seen. It might be it just reached the court clerk who said, nah, fuck off. So when she says never ruled upon, it might be that it wasn't ruled upon by the judge. But this is something in California that the court clerk can accept, look at, and then send back. We are not going to change the record. But in Laura's head, if the judge doesn't decide it, it hasn't been ruled upon. That is my guess. The following day, petitioner filed a notice of appeal, which under settled California law divested the trial court of jurisdiction over the pending motion. And she has here case law. The motion has never been adjudicated in any court. As a result, the facts underlying this appeal are not before this court. The official record, 5 pages documenting a 4-minute proceeding, reflects only that petitioner did not appear, and the matter was dismissed. It contains no reference to the 2 written pre-hearing notifications petitioner sent the court advising of a life-threatening medical emergency. Oh. The court's written acknowledgements of those notifications received before the hearing began, the medical documentation she submitted, her offer of HIPAA authorization that no one accepted, the ADA accommodation request she raised and which were denied, the ex parte communications between court staff and respondents' counsel from which she was entirely excluded the day before the hearing, or her formal written refusal to waive her statutory right to an official court reporter, a refusal that, under the court's own written directive, required the matter to be continued. This is, in my opinion, pure hallucination. Pure hallucination. And we will get to it. We will get to it. That record cannot support meaningful appellate review. An opening brief filed on it would misrepresent the proceeding it purports to address. 60 days to correct the record, obtain counsel, and brief the actual issues presented against the backdrop of active state bar proceedings against both respondents' attorneys. Oh, wait a minute here. Against the backdrop of active state bar proceedings against both of respondents' attorneys who appeared at the dismissal hearing. Yeah, that would be Laura Owens making a bar complaint against Omar and I forgot her name, which will go absolutely nowhere. Absolutely nowhere. I can almost guarantee it will go absolutely fucking nowhere. It is. But it's her filing. She can lie as much as she wants. And she does. Rachel, thank you. Thank you, Rachel. Yeah. So this is just Laura going, they're not good. State Bar, do something. Won't happen. Who appeared at the dismissal hearing, and new conduct by respondent requiring legal investigation. What? What the fuck did Mike do to you? Nothing. Nothing. New conduct? What? Oh, It's not a delay. It is the minimum necessary to proceed responsibly. Here we go. The record versus what actually occurred. The official record. The reporter's transcript on appeal spans 5 pages and records the following. At 9:26 a.m. on November 5th, 2025, the court called the case, noted petitioner's absence, appointed a privately retained reporter pro tempore because no official reporter was available, which is perfectly fine and legal. Perfectly fine and legal in California. That if the court, hey, we can't get a court reporter, either party can go, we will supply one. And Mike and Omar supplied one. Mike, Omar, and Rachel. Yeah, here's one. We got it. Dismissed the matter for non-appearance, permitted respondents' counsel to reserve on insurance fees, and adjourned. The entire proceeding lasted approximately 4 minutes. Yeah, because you didn't show up. Here she goes. November 4th, 2025, the day before the DVRO renewal hearing. At 10:05 a.m. on November 4th, the court emailed all parties that there was a high chance no official court reporter would be available the following day, and that because this was a DVRO matter, the matter would need to be continued if any party declined to waive. Petitioner relied on that representation. She did not waive. That's not entirely what happened. Because in California, either party can get a court reporter if there is no official one ready. There are companies in California who only rents out court reporters. What followed was a series of communications from which she was entirely excluded, as you have no right to be included in until it's resolved. At 10:10 a.m., 5 minutes after the court's all parties email, respondents' counsel emailed the court's department directly, which they can, without petitioner, which they are allowed to. It's ex parte communications between the court and one party that has not to do with the case itself, but the administration of it, which is allowed. And as long as when the communications are done, they notify. We'll get to that. To inquire about securing a private reporter. That discussion continued throughout the afternoon. At 3:32 p.m., court staff asked whether the proposed reporter was certified. At 3:42 p.m., respondents' counsel confirmed one had been secured. At 4:08 p.m., court staff asked for her name and license number. Petitioner was not copied on any of it. Because it doesn't concern you. You tried to waive. Yeah, that was your only right. She was added to the chain at 4:40 p.m. You were notified the day before the hearing. After the reporter had been identified and approved through a process conducted entirely between one party's counsel and the court, which is fucking allowed. Upon receiving that communication, petitioner immediately filed a formal written objection invoking Government Code Section... What the fuck is this? Yeah. California Government Code Section allows parties to arrange and pay for a private certified shorthand reporter to serve as an official pro tempore reporter when a court-provided reporter is unavailable. The court must appoint this reporter unless there is good cause not to. You being a cunt is not good cause to not hold the hearing, Laura. And California Rules of Court ruled, okay, let's see what that is. California Rules of Court, Rule 2.956C, pertains to the provision of court reports in civil cases when an official reporter is not available. Yeah. Ta fucking da. So you are invoking the two rules that allows the court to admit a privately secured court reporter. That's not how it... Under Rule 2956C1, the court was required to reflect on the record whether each party waived or refused to waive. The minutes are silent on that subject entirely. The admission includes the reflection. It is implied that the judge made that reflection. At 5:08 p.m., the first moment petitioner had confirmation the hearing might proceed, her family purchased emergency last-minute air travel from Scottsdale, Arizona, where she currently resides, to San Francisco for the following morning. She transmitted the confirmation to the court that evening. She hadn't even booked her plane ticket. She was always planning to not show up. Always planning to not show up. Oh, Rosalind Raid. Hey, Rosalind. Thank you. Thank you. Yeah, she never intended to be there. Never. So for her, that was official court reporter. Oh, God sent. And then, oh, shit. Omar got one. I object. Fuck off, said the court. This is according to rules. Get your ass over here. And by the way, this was November 4th. The entirety of the Owens family is supposed to be broke. Who paid? Or are everybody in the Owens family lying about their economics? November 5th, the morning of the DVRO renewal hearing. In the early morning hours of November 5th, petitioner suffered a sudden and severe medical emergency. She was vomiting blood and was transported to Honor Health Hospital's emergency department, where she was admitted for a procedure under anesthesia. Folks, here's what happened, in my interpretation. Laura Owens went to the bathroom and then went out to her mom and dad. I vomited blood, call an ambulance. So they called an ambulance, took her there, and admitted for a procedure under anesthesia. You know what that is? Camera, throat, numb throat. That's the anesthesia. That's the procedure. They were looking down in her stomach. Okay, what's going on here? Probably found absolutely nothing. That is what this section is all about. She made it all up. At 6:21 a.m., more than 3 hours before the matter was called, petitioner emailed the court and all counsel described her condition, her hospital admission, and her physical inability to appear. She made the situation herself. describe the condition, blah, blah. She submitted medical documentation, not hospital records. Medical documentation she wrote, not medical records. She could have in there after the, she could have asked the doctors, get me a copy of what just happened here, and because I have to send it to court. She didn't. She was just verbally vomiting, spewing words. Oh, I'm dying again. She submitted medical documentation and offered without reservation to execute HIPAA authorization permitting immediate independent verification by both the court and respondent's counsel. Not exactly how I remember it. How I remember it is that more or less she said or wrote, I can provide this if needed. Here's the thing, Laura. Those papers should have been in your email already. You have access to your medical records. It's very easy. Go into your medical records, ask the doctor. I mean, she did nothing of that because she didn't want to appear. That's it. She made shit up. She went to the hospital. They looked in her stomach. They found nothing. So she wasted emergency personnel's time, resources, somebody who was actually sick could have used just to get out of court. Just to get out of court. Hey, thank you, Rosalind. No way she has insurance either. Yeah, it should be really, really easy to get those papers. Let's see here. Court manager Francis Yokoda replied at 7:11 a.m. Email received. Thanks. That's all she has to do. Because Laura, you knew you were supposed to be there. Court doesn't care if you're wheeled in on a hospital journey. You get your ass in there. At 6:53 a.m., petitioner sent the second notification. So she sent the second before she even got a reply. A second notification. She was being formally admitted. The procedure under anesthesia was proceeding. She was expected to remain hospitalized overnight, and she requested a continuance. If they found something, yes, she would have been hospitalized. But they didn't. You know how we know that? Because you have thus far not submitted a single medical record from that event. Not a single document. Not one. Only her word vomit. Court manager Yokoda replied at 7:33 a.m. Good morning, Miss Owens. Email received. Thanks. All she needs to do. Because it was only your words, Miss Owens, without actual medical records attached. Can you guess how many people tries to get out of court by phoning in bullshit things? We've all seen when I check in on George Simpson, he don't care if it's bullshit. He calls out bullshit. The court thus received written notice of a life-threatening medical emergency. No, they didn't. They got your email saying, "Oh, I'm dying," after you tried to get out of court several times, or at least once before. And acknowledge it accompanied by medical documentation. No, your words or in an email, not medical documentation, not actual medical documentation. An offer of HIPAA verification and acknowledge it in writing twice before the matter was called. No continuance was considered. The verification petition offered was never requested. You are supposed to be there. You are your own lawyer, or you were your own lawyer in that case. Get your ass in there. The case was dismissed in 4 minutes. The reporter's transcript contains no reference to any of this. They don't have to. The order was, get your ass in here. That was the not verbatim, but that was what the court. Yeah, they already continued it with 2 weeks because you had a medical emergency, and now all of a sudden you have a new medical emergency. None of them were verified via actual hospital records. None of it. The consequences. The record before this court supports only one inference. Petitioner failed to appear without explanation. That inference is false. No. Without a justified, a good cause, with actual hospital records. That inference is false, and it forecloses the appellate review this case requires. It is also the inference respondent has been exploiting publicly. He has made statements both while the restraining order was actively enforced and continuing as recently as the date of this filing, characterizing himself as a victim of petitioner. A finding no court has ever made. His fucking opinion. He can state that. It's not defamation, Laura, just because your fifi is hurt. When people are calling you out for being a lying son of a shit. Yeah. And implying that prior judicial findings have been vacated or reversed, which is likewise false. No prior finding has been vacated. The restraining order, all of it, are vacated. The previous one expired. It's no longer there. The November 5th dismissal was purely procedural, entered without any evaluation of evidence or determination on the merits. They don't have to, because you didn't show up. You chose to not show up. The incomplete record provides no corrective account because it does not reflect the circumstances that actually produced the dismissal. If it did, Laura, if the record actually reflected what you did, I would be surprised if not criminal charges were to be produced in California as well. Three, the motion to correct and augment the record has never been ruled upon and must be addressed before briefing. The motion to correct and augment filed on December 3rd, 2025, pursuant to California Rules of Court, Rules and Code of Civil Procedure sought to place before this court each of the categories of omitted material described in Section 2. It was not opposed or denied. Mike doesn't have to do shit. It wasn't denied by a judge, but to my understanding, in California, this can be done by the court reporter who probably answered you. Nah, this is what happened. If this is ChatGPT AI writing, I can check. Load files. Let's see here. Okay, processing. So let's get back to that. It became unreachable when the notice of appeal filed the following day divested the trial court of jurisdiction. It has never been adjudicated. This court has authority under California Rules of Court to augment the record to include materials necessary to the appeal's proper determination. The materials at issue, petitioner's pre-hearing medical notification, and the court's written acknowledgments, her medical documentation and HIPAA offer, her formal written non-waiver of her right to an official court reporter, her denied ADA accommodation request, the ex parte communication from which she was excluded. You weren't. You were notified. At 4:40 p.m., you were queued in. And her emergency travel booking are not peripheral. Why did you have to have an emergency travel booking when you were already supposed to be there? And who paid for it? They are the factual predicate of every issue this appeal presents. Preparing an adequate motion to augment requires identifying each item with specificity, establishing provenance and authenticity, and demonstrating relevance to each issue on appeal. Petitioner did not understand this to be a necessary path until legal counsel identified the record deficiency as the dispositive obstacle to representation in the weeks immediately preceding this filing. You represented yourself. You have the responsibility to know all this when you represent yourself. And here is the thing. Until legal counsel identified the record deficiency, who? You don't name them because they never took your case. You can't claim you got legal advice from somebody you don't name. She, again, now, petitioner, yeah, but she tells me, yeah, Laura didn't write this. She has moved as promptly as circumstances allow. It is the foundational step without which no opening brief can responsibly be filed, and 60 days is the minimum time necessary to pursue it. 4, both attorneys who appeared at the dismissal hearing are subjects of active state bar proceeding arising from their conduct in this litigation. That is you, Laura, phoning in a phony bar complaint. Prior to the November 5th, 2025 hearing, petitioner filed, petitioner, Laura, California State Bar complaints against both attorneys who appeared when she was dismissed. Omar Raul Cerrato, Esquire, lead counsel for respondent, who secured the dismissal and immediately moved to reserve on attorney's fees, which he can, and Rachel Elizabeth Juarez, Esquire, associate counsel. Both complaints arose from conduct in connection with this litigation and were filed before the hearing occurred. And another way to, oh no, I'm losing. So she throws stuff against the wall and hope it sticks. Hopefully, the California State Bar can decide on this as quickly as humanly possible and tell her to fuck off with her vexatious litigation. Yeah. All bar complaints are investigated. It doesn't mean it has merits. Both complaints have progressed beyond intake. Yeah, that's how they do it. Each has been assigned to a named state bar trial counsel and has required the production of specific documentary evidence in furtherance of the state's bar's evaluation. Yeah, that's you who have to provide that. The misrepresentation under investigation include public statements made by counsel about the DVRO renewal proceedings, specifically statements about petitioners' whereabouts, the you being spotted on a horse competition while claiming to the court that you were deadly sick. Sure. And about whether she offered or refused to provide medical verification, and offer the documentary record confirms she made. No, it doesn't. The implications for this application are direct. Petitioner must prepare an appellate brief without counsel in a proceeding whose central facts are simultaneously under active state bar investigation because of you. You can't. Against attorneys who are subjects of that investigation, who hold every structural advantage over an unpresented party. You chose to represent yourself. You are the lawyer, Laura. It's your own damn situation you put yourself in. Courts have recognized the fundamental fairness concerns this dynamic creates. Let's see what this is. Here it is. This is family court. Oh, okay. Local superior court rule and trial scheduling order in the family law. I'm just skimming through this. Okay, so here in this case, they improperly deviated from state law in actual trial. This, Laura, was not in trial. This was your own doing by not showing up for a DVRO hearing. That's the difference. One of the differences. And in my opinion, the court followed state law. Those concerns are materially heightened here, whereas here, the professional conduct of opposing counsel is under active regulatory review for alleged misrepresentation about the very facts at issue on appeal. The extension petitioner request is not dilatory. It is the minimum consistent with proceeding responsibly. 5. Petitioner has diligently pursued appellate representation and faces documented financial hardship. Petitioner's pursuit of appellate counsel has been continuous and in good faith. No. You might have called a few lawyers, and you might even have called Ginras. But who? Present us with names. Isn't it weird that she doesn't present names or documents? Strange, isn't it? Because every time she's done so in other proceedings, she can't stop lying. The written declaration she received in the weeks immediately preceding this filing from 2 separate sources of legal counsel, each of whom reviewed this matter substantively before concluding that the incomplete record precluded representation. Where are their affidavits? Or Miss Owens? Who are they? Or evidence of that diligence notice failure? Laura, you don't provide names. So the court only has your word of it. And your word is worth less than nothing since, you're not convicted yet, but oh my God, I hope you get convicted. Both expressly invite the petitioner to reapply once the record is corrected, confirming that the appeal is viable. No, they don't. They would never confirm an appeal is viable. Never. Not a lawyer who wants their bar card intact would ever confirm without taking your case that an appeal is viable and that a clear path to representation exists. That, as I said in the beginning, they saw her on a consultation or talked to her on a consultation. She told them, the record is incomplete. They didn't do this, this, and this, and this. And they probably told her, well, I can't take your case until that is rectified. But how is she going to hire these attorneys if she doesn't have money? Her inability to retain private counsel is not a matter of preference. Petitioner is currently a party to a bankruptcy proceeding with a hearing scheduled before the United States Bankruptcy Court for the District of Arizona on May 14th, 2026. This no longer applies because the parties in her bankruptcy case agreed for a dismissal. And she is not allowed to file for bankruptcy for a full year. So this here, gone. Her claim of being financially inept, no. The financial circumstances that necessitated that filing are the same circumstances that have made private appellate representation inaccessible. A 60-day extension would allow her to address that hearing, continue her search for representation, and pursue the record augmentation that must precede any meaningful briefing. Yeah, all of this here, gone by your own doing. 6. New conduct by a respondent requires investigation and may warrant independent legal relief. Petitioner has identified conduct by a respondent raising questions on 2 distinct legal theories, neither of which she can adequately evaluate without counsel. Because it's bullshit. First, when a renewal petition is filed before an existing order's expiration, the order remains operative pending adjudication. Petitioner filed her renewal petition on July 10th, 2025. The order therefore remained in force through at least November 5th, 2025. Respondent participated in public media appearances made during that period that were broadcast to a substantial national audience. The then active order expressly prohibited respondents from disturbing petitioner's peace, harassing her, and contacting her directly or indirectly by any means. I'm not sure about the language in that. He can talk about himself and his case to anybody he wants. Those recordings contain material falsehoods about petitioner directly and irreconcilably contradicted by respondents' own sworn deposition testimony on January 2018, by audio recordings in petitioner's possession, and by contemporaneous text messages in petitioner's possessing reflecting respondents' own words, establishing that the misrepresentations reflect not a difference in recollection, but deliberate falsehood. Their broadcast foreseeably generated sustained harassment directed at petitioner. Fuck you, Laura Owens. Fuck you all to hell. All of that was addressed by Omar in this hearing, which you didn't show up to. All of it. All of it. Everybody knows that you lied, how you lied, how much you lied. probably why you refused to show up for the hearing, because if you had done that, it would have been clear for everybody involved that you are a lying sack of worthless shit. Second, and independently, respondent has made public statements beginning in the period immediately following the November 5th, 2025 dismissal. Boom, then it's gone. You have no DVRO, dismissed. Now you can say whatever the fuck you want. Dismissal continuing as recently as the date of this filing, containing the same category of deliberate falsehoods, contradicted by the same deposition testimony, audio recordings, and contemporaneous text messages described above, distributed to a substantial national audience. The deliberate public dissemination of materially false statements about a person made repeatedly and to a national audience in a manner that foreseeably generates sustained harassment directed at that person constitutes conduct that destroys the mental and emotional calm of the subject of that conduct within the meaning of Family Code section blah, 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 blah. California courts have held that such conduct need not occur within the context of an existing order to constitute abuse cognizable under the Domestic Violence Prevention Act. It is precisely this category of conduct that warrants the issuance of a new protective order. Laura Owens, there are 750 miles between the two of you. Not at any point in time between 2018 and up until today has Mike done anything but say, I don't want anything to do with her. I want this to be over with. I'm married with a kid. This is abuse, Laura. You are abusing Mike. You are a horrible human being. Family Code. Determining the precise legal basis for relief and its full scope requires analysis petitioner cannot responsibly undertake without counsel. Poor you for not affording to ruin people's lives anymore, but you still do it. 7. The balance of equities compels relief. On one side, a self-represented domestic violence survivor. For fuck's sake, you lying sack of whore. Whose ADA accommodation requests were denied. Who suffered a life-threatening medical emergency. No, you didn't. On the morning of her hearing, twice she did that. I can't come to that hearing. We have to postpone. And they postponed it. Life-threatening. Ooh. And all of a sudden, life-threatening again. Yeah. No. Who notified the court in writing before the proceeding began. Whose notifications were acknowledged in writing before the matter was called. Who submitted medical documentation. No, you didn't. You did not supply the court with actual hospital records. All they had was your description of it. That's not medical documentation. And offered HIPAA verification that no one accepted. Nobody cared. Here's what you don't offer it. You supply it. Here's the medical record. Here's the hospital record from that day, what they did. And here is that doctor's, with name, the procedure, and the finding. Who was dismissed despite all of this, who the day before the hearing was entirely excluding from ex parte communications. Yeah, that was ex parte. And no, you were queued in 4:40 p.m. Ta fucking da. You brought this case, Laura. Nobody else. You brought this case against Mike Marraccini. Nobody else. Then it's your responsibility to fucking be there. excluded from the counsel regarding whether the hearing could legally proceed. Communications that determined the outcome of that question without her knowledge or participation. You were notified at 4:40 p.m. the day before the hearing. You were notified. Who filed a formal written objection to the privately retained reporter and explicitly declined to waive a statutory right to an official court reporter, a refusal that under the court's own written directive required the matter to be continued. No, it doesn't. The judge can accept a privately supplied court reporter. In the order to accept it is implied reflection. It's not that hard. You'll find a motion to correct the record that was jurisdictionally stranded the following day and has never been adjudicated. Probably got stuck at the court reporter who said no. Who diligently pursued appellate representation for months and received declinations in the weeks before her deadline that identified a correctable path forward and invited reapplication once that path is taken. Name that lawyer. Who faces documented financial hardships evidenced by a pending bankruptcy proceeding, which is now moot. Because Laura Owens lied to the bankruptcy court. She supplied lies, documented lies to the court. Because that is all she does. Who must proceed against attorneys under active state bar investigation. You reported them. Again, your own damn fault. You created this in order to have an argument. Because you're a fucking cunt. If you haven't noticed by now, I curse a lot. If you don't like people cursing, I'm not for you. And who has been subjected to sustained and documented harassment as a direct and foreseeable result of respondent's public conduct. Oh, boo fucking who. She has for 60 days, time that will allow her to correct the record, reapply for representation, and brief this appeal properly. On the other side, a party who publicly solicited and raised in excess of $50,000 for his legal representation in this matter from an online communities whose members have directed sustained harassment at petitioner. Sue me, Laura. Problem of suing over the pond is that you actually have to pay for it. And that is fucking expensive. So she tries to use that people want to support Mike against him. I don't think that will work. Harassment that flows directly from respondent's public portrayal of himself as a victim, a portrayal the judicial record does not support. It does. With Omar's motions, once we heard all of it, not the cherry picking you did, Laura. Once we heard all of it, we knew you were a cunt against Mike as well. Respondent stipulated to the original DVRO, yeah, rather than contested. Yeah, because he didn't want you around. Granted the 2020 renewal on the merits, on the previous one, because he just didn't want anything to do with you. The order remained in force for 7 years. Respondent has nonetheless made public statement contradicted by his own sworn deposition testimony January 2018, blah, 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 blah. The public campaign built on those misrepresentations has generated a sustained harassment petition on our faces, financed in part by the same community that funded respondent's legal representation in these proceedings. Respondent enters his appeal fully funded. No, he doesn't. Yeah, folks, Mike has raised over $50,000. His legal costs, as of now, are double that. Because of you, Laura. Because of your frivolous filings. Respondent has disappeared, fully represented and facing no cognizable prejudice from a 60-day extension of time. And then she goes on to the 2018 restraining order, which he stipulated to because he thought the nightmare would be over with it. But Laura Owens is a serial pregnancy scammer, a serial abuser of the court system, the justice system, and men. She can't have it. She has to keep punishing people who doesn't want anything to do with her. It's mental. Absolutely mental. And that account from disinterested witnesses who had never met either party has never been challenged in any court. No, because you didn't show up to the last one where it would have been challenged in its entirety. And then she talks about the Domestic Violence Prevention Act, which is a good act. Problem is, there are women like Laura Owens out there that will use this over and over again. Conclusion: for the foregoing reasons, petitioner respectfully requests that this court grant a 60-day extension, accept this application as timely filed, grant such other and further relief as the court deems just and proper. Yeah, and here is why they granted it. Because this is all they care about. Did you file in time? Did you make some arguments? Okay, here's your 60 days. I don't think they cared about the rest of this bullshit. Petitioner hereby advises this court and places respondent on formal notice that independent of the outcome of this application, she intends to seek a new domestic violence protective order arising from respondent's recent and ongoing conduct. Dated April 23rd, 2026. Laura Owens in pro per. So it was granted. She now has a deadline of June 26. Before that, we will know if her criminal case, if she will take the plea or not. We already know that her attempt to hide her finances via bankruptcy court failed miserably. Now we know so much more about the bullshit she has done throughout the years. We know that she has been a leech on her father for her entire life. She has never had a job. Nothing. She just attached herself to stuff her mom did or her sister did. Never had a job. 35 going on 36 years old. Never once did a day of work. And it's who pays her fucking rent? Where is the money that funds Laura Owens and her mother's bullshit? Could have hoped. I hope, even though bankruptcy court accepted the dismissal, that amount of lies she produced to the bankruptcy court and documents she refused will render in something from the feds. You can hope. You can always hope. Honestly, I don't think so, because there are so many bankruptcy cases. If they took everyone, as important as we feel it is, the feds might not see it the same way. Her parents fund her. Yeah, but with what? The only thing they have left is that is, what do you call it? Retirement money. And that won't last forever. Laura Owens' redeeming quality is that she provides content for wonderful streamers like me. Yeah. That she does. This is not fair, folks, but this is how people can use the judicial system to abuse people. Laura Owens has done this for a decade. And she won't stop until the justice system tells her, no, you're not allowed to file without court approval as a vexatious litigant. You are not allowed to. That's a high bar to reach. But if anyone reaches that high bar, it is Laura Owens, who anywhere in the United States should be met with, you have to have a the court approve of you, and you have to pay. No longer, oh, financial hardships. No, we don't care anymore. Pay. Which will sadly take time. But what is awaiting us now is she has an extension to June 29th to file this, to correct the record. I doubt she can and will. Then she will try to get a new extension and a new extension, and then not show up and keep doing this. Rosalind Duke, legal question. Since she is initiating this from Maricopa, does it make it within the jurisdiction of County Attorney Rachel Mitchell? I do believe, even though she resides there, she's filing it in California, which makes California the jurisdiction for this. You could argue this is cross-state stuff, but it's not fair. So Derek, sorry, I didn't bring this up earlier. Thank you for the super sticker. Thank you so much. It is a cup of coffee which says tired. Thank you so much. Yeah, it is 11:15 p.m. where I am, and I have work in the morning. This LMP, she boldly lies in this documentation, saying she wasn't granted an ADA accommodation. She was granted an accommodation. Yeah. And no, she can't correct the record because that is all the record that was needed. Because if she had a medical emergency, and she only, oh, if you want to, I can offer you this. No, you provide the damn hospital records and a note from your treating physician. And she didn't. She only offers it. Nobody wants it. No, you provide it. That's the thing. You provide it. Yeah, and all of this document here, she doesn't reveal who the lawyers she talked to, even though she more or less claims she was given legal advice, which also, because once she claims she got legal advice, then they have to provide it. Yes, hello, my name is that and that. I'm in good standing there and there. Laura Owens came to me for an hour of unpaid la la la, and I told her to come back once she had something I could work with. I do not represent her until she does. But she doesn't. And she won't find anybody because she only got a 60-day extension, and that is how she does it. Prolong the pain for her victims. Thank you, Auntie M. Gifting 5 memberships. Went to Winks and Wilts, Jen Adams, Toadette, Jen the Couch Fairy, JKD back. Yay. Yay. Thank you so much. Thank you. Let's see here. And oh, look at this. Within this stream, Mike got $150 to his fundraiser. Thank you. Ooh, thank you so much. Thank you. Well, folks, all we have to do is wait and see. Now, what else do I have for maybe tomorrow? Well, we can go through tomorrow because Omar has submitted for lawyers' fees for, I believe, $109,000 in lawyers' fees that he asks of Laura Owens. They have a hearing about it in later than June 29th, I believe. But we can go through that tomorrow. And also with this bullshit now from Laura Owens, Mike Marraccini, if she goes through with her threats to go forward with a new application for a DVRO, yeah, his cost will increase. She does this for free. I mean, it only costs her time. And poor Mike, just trying to get away from her, over $100,000 in lawyers' fees. But we can go through that tomorrow. And tomorrow I will also explain, okay, what are these lawyers' fees? Okay. How could it be for a restraining order? How could it reach over $100,000? And we can go through that as well. And I can check if Dave has time, so he can help us go through it, since Dave is a US-based attorney. But that is all I had for you for today. Thank you, everybody, for showing up and helping us, helping Mike. Thank you. So from me and Mr. Jingles, who sadly didn't make an appearance today, you all have a good one, and remember to hug your family. Unless your family's shit, then screw them and give your love to the people who deserve it. See you tomorrow. Bye-bye.
Laura's got a secret, oh what a tale. She spins a wild story, sets sail without a sail. Fake baby bumps, she's got tricks up her sleeve, but the boys see through it, they just can't believe. Oh Laura, 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 what did you do? Play and pretend just to make it through. The boys fight back, they're standing tall. Laura's big surprise is no surprise. Points her finger, you're the bad guy now, but truth's got legs and it's taken a bow. Her plans unravel like a thread on a spool. Life's not a game and you're breaking the rules. Lies and lawsuits, so what a show. But justice is coming, it's starting to grow. You can't win hearts with tricks or a fight. The truth shines brighter than a starry night. Remember, don't twist what's true. Life's much better when you just be you. Laura's learning the hard way it seems. Honesty's the hero in everyone's dream.